Awesome. So I got this recorded. Just make sure. All right, cool. And I'm gonna dive into it. And because it's recorded, again, I post all the calls around Wednesday, sometimes Thursday, guys, because I have to upload them. I gotta make edits, make sure everything is smooth. There's no copyright whatsoever, the whole YouTube thing. So that takes a couple of days depending on, my time. So, but I make an effort to get them up by like Wednesday, Thursday every week. So for all the calls we have Sunday, Monday, and Tuesday, just expect for them to be posted in the campus around those 2 days. I know last week I was able to get them up by Wednesday end of night. So that's my goal for this week as well. Um, so to dive in and talk about the next process here, right? Because I know a lot of you guys have been really diving into the rest of the material and you've either already gone through the first round and you've mailed your letters, you've sent your power of attorney, you've sent um, all the other letters, including, redemption of instrument and all paid, all accounts are paid, right? Really just informing them and providing instructions to the companies and indenture trustees to perform on the instrument that you guys have sent, right? Now, what we're diving into today is what if they don't accept it, right? And what if they don't actually take it? What if you don't see that reflect on your account? So, should a financial institution deny your tender of payment or simply not respond within a time frame that you give them that you have given them? So, some of you I saw put in 15 days, 7 days, 30 days. You give them, however much time you feel like they need, right? Personally, I give them around 15. Depending on what the situation is, I can do 30, but because I know a lot of these companies want to postpone everything, and I know it's all payments and we want to do things timely. I personally just do 15. There is no like, um, you know, cut clear, dry instruction on how long you should do it. And if you guys find any, feel free to share. But I haven't found anything that's like cut and grained and says, hey, you gotta submit this within X amount of time, right? Not like with credit repair companies where they have 30 days to respond. I haven't seen anything like that, but I'm just going based off of what I know and how everything works, right? So the standard time's 30 days, but you can give them 15. Like I said, I give them 15. So understanding what dishonor is, right? What is dishonor of a payment of instruments, right? So a note that doesn't specify a payment date is payable on demand. So if you received some sort of a payment and there was no due date on it, right? Then you basically are not obligated to pay it right then and there until the payment is requested, right? Because it's only due when it's requested, right? So, and I'm gonna give you an example of that, right? So it's deemed dishonor if not paid on the date of presentment. So what I mean by presentment is if they're trying to collect it on that day and you don't have the payment, then it's dishonored. But because they didn't give you a due date, all right, you didn't actually give a time frame for it, then the only way it's due is if there's a presentment, right? Right? There needs to be a presentment, and there's no time frame behind that. An example I share here is, imagine that you lend a friend $10, but then you say but you say when they have to pay you back, right? That means that they have to pay you whenever you ask for it. So now, if you go go to them one day and say, "Hey, I need $10 now," and they don't give it to you, that means they failed to pay you when they're supposed to, right? That's what dishonored means. And you've basically lent them money. You didn't give them a date, and you simply came back at a later time. There was no specific time that you came back. It was just at a later time, and you requested for it. And at the moment they didn't actually pay you when you asked for it, and they said no or they didn't have it, that's considered dishonor, right? Because in the beginning, because there was no actual time frame, there was no actual due date, then there is no dishonor because there was no due date. But in this case, when we're dealing with remittance, there's a due date. And when you're dealing with remittance, you're making a payment, right? And that payment is made should be made when it is presented, right? Because we're not dealing with this scenario here when we're dealing with remittance where, there is no due date and then all of a sudden you get to decide, when you're going to collect. That's not how it works, right? We're dealing with a completely different scenario. All right. So when we're looking at UCC 3-502A, if the note terms require presentment or the note is payable at or through a bank, in the remittance process, it is payable through a bank. The note won't be dishonored until the presentment or the presented until it's presented and not paid on the latter of the presentment date or date the note became payable. In the remittance case, the note becomes payable from the date you endorse it and they have received it. Imagine you receive a check from someone, but instead of cashing it right away, you send it to the bank or process. The bank won't say the check is bad, dishonored, unless they actually try to cash it in and the money isn't there. In the remittance case, the note becomes payable once the banks get it and you've received it. But if the bank tries to collect the payment and the payment isn't made, it is then in dishonor, right? So you're basically looking in a situation where you're just simply trying to cash in a check and they won't say it's bad until they try to cash it, right? And that's this scenario here, right? And these are two different ways to look at instruments and payments and dishonor, right? Because my goal here is to try to break down different perspectives of dishonor. And dishonor can be perceived in different ways. It's not just like a one-way road when you're looking at dishonor, right? You have a couple forks in the road, right? One road leads to, the payment not having an actual due date, and it simply just needs to be paid when somebody tries to collect. The other one is it has a specific due date. It has to be paid on an exact date that it was um, supposed to be paid. And if it wasn't paid, it is now considered dishonored, right? So there's different ways to look at it. So what I did here too as well, guys, is I actually shared where I got this information, right? I got it right from the same source. I always use Cornell, right? I included this stuff as links so that you guys can see this. Dishonor is a refusal to honor and pay an instrument that is presented for payment or settlement. A bank or financial institution can choose to dishonor an instrument, and if the institution has a valid reason to do so, such as fraud, forgery, and insolvency of a person who originally gave the instrument to the drawer. When institution chooses to do this, however, it must give timely notice of dishonor to the drawer or whoever has presented this instrument. If the institution, specifically a bank, cannot provide valid reason for why it is dishonored, the instrument it has wrongfully dishonored under the Uniform Commercial Code, the bank is liable to its customer for damages caused for wrongful dishonor, right? And to simplify that, right, it's basically saying here, think of a remittance note like a gift card, right? So if the gift card isn't activated until the store receives it and scans it, right? So once you have it and process it, it's officially ready to be used and it's payable, right? But if you go and use it and the system says there's no money in it, that's when it's dishonorable, right? So it's only dishonorable when you can't redeem any money from it. It's dishonored when you can't redeem any money from it. And that's similar to the bank, right? Another example here is let's say that you request money from your friend through like Cash App or like Venmo, right? Or PayPal. But they set it up so that money comes from their bank, right? The app won't say that the payment failed until it actually tries to take money from the bank. So Venmo itself is allowing you to process everything. It's allowing you to put the money in, the amount. It's allowing you to send it to a person, and it is not going to be deemed dishonored until when they try to process it from the bank account and it's rejected. That's when it's dishonored, right? So those again, that's those are some examples I'm trying to share with you guys of some scenarios around how dishonor works, right? Because this is the true law Cornell definition, and this is just an analogy I put in place so you guys can have an idea on how to picture this, right? Because you have to be able to understand how this works on a different sense because the legalese is very confusing, all right? And I'm actually explain another reason why I added this link here is because I encourage you guys to go in and check and click every single one of these definitions, right? Because when you check and click all these definitions, there's way more, right? It's just a rabbit hole of more information, right? Now, while I'm just simply going through everything related to this specific dispute method, right? You're gonna have to do your due diligence of reading through some of the material and leverage the community to ask questions because everybody in here is all going through the same stuff at a different time. And there are some people here who are actually pretty well versed on some of it and others aren't. And the whole point is for everyone to work together to figure this out, right? I'm going over this based on my perspective and what I have interpreted this as, right? Now, now that we've broken down dishonor, we've got instruments here, right? We've covered this before in our previous calls, right? With instruments, you're dealing with something a little different. An instrument is written legal document, right? An instrument's what we processed when we were doing the bill remittance, right? This document that records a formal execution of legally enforceable acts or agreements and secures their associated legal rights, obligations, and duties, contracts, wills, promissory notes, deeds, and statutes passed by competent legislators are examples of legal instruments. Typically, legal instruments must be read as a whole, um, with every part interpreted in accordance with the whole. Jurisdictions differ on who may draft the legal instrument, right? So most states allow non-lawyers to write down their own instruments, such as wills, contracts, but do not allow non-lawyers to invade in the field of legal practice by charging third parties to draft complex legal instruments on the behalf that secure legal rights. The legal instrument is considered executed once it has been given validity and legal effect. For example, signing a contract executes the contract. That's exactly what it means, right? The instrument can be used as evidence to prove the existence of such acts or agreement, right? So when you guys are endorsing an instrument and you've signed it and you basically created a transfer from one party to the next, that serves as evidence, right? That alone serves as evidence because in a form it's a contract. Historically, instruments were not considered properly executed until they had sealed with wax or stamped, right? Key word. There's wax or stamped. And we stamp, right? We're stamping and endorsing, guys. The requirements simplified authentication and enforcement, right? So it simplified it with the stamp and the wax, right? But today it has been done away with most American jurisdictions to allow for greater ease of contracting. However, a person who falsifies materially alters a legal instrument with the intent to defraud another is guilty of a crime of forgery, right? So, I mean, that one's pretty cut and dry. So, think of it as a legal instrument, right? It's a promissory. So it's a permission slip from school, basically, where, you're going to ask your parent to sign it so they can give you permission, right? And that permission slip is a valid proof that you can literally go on the trip or, participate in any activities that require consent, right? So, so if a teacher needs to check if you're allowed to go, they will look at the permission slip as the proof, right? And the same thing when you're endorsing. The instrument is a proof that the bank can now use it to cash in and make any payments or process any payments. So that's what that is, right? So just like legal instruments in real life, permission slips create rights and responsibilities and must be properly executed to be valid. So in this case, right, we're working with an instrument that is required to be processed at the bank. And if it's not processed, right, they're now claiming, they're potentially claiming that it's not valid, but they have to express it, right? They have to express whether they're not going to accept it. They can't just sit on it because it has to be one or the other, right? Did you not honor it? And if you didn't honor it, what are the reasons? Most of the time, if you don't see any remedy, you're not hearing back from them. That's what they do. They just keep quiet. So that's why you have to send notices, right? You're sending notices because you've sent an instrument, right? And they have to properly execute it. They have to properly execute it. They have to go and redeem it at the treasury. Hence why we added a restrictive endorsement to it. Now we're dealing with the check, right? And I broke down some of these definitions, guys, because I kind of dove deeper into the dishonor piece. So if you notice a lot of this stuff, so instrument, check, timely, there's presentment I included in there. There's some key words I'm slowly breaking down for you guys, but there's so much more to learn. I'm going over what I think personally, um, you guys are going to need to know, all right, and understand, right? Because this is all, it comes back down to understanding why we're doing this. This is not a matter of just sending around to and following up with the company. This is like, you have to understand, why are we doing this? All right. So now that we understand what dishonor is and we understand that the instrument, right, needs to be properly executed, right? It needs to be properly executed. We have now what's our check, right? The check is a draft upon an account that is used to instruct the bank or financial institution to transfer funds from the payer's account. The person who, and that's why we were paid to the order of. We turned it with the special endorsement. That's what the special endorsement, in my opinion, is doing. The special endorsement is payable to the order of. All right, it's payable to the order of. And that's what turned it into the check. It was endorsed. And so now they can redeem it, right? So basically, if you look at this scenario, right, think of it of the check like a fast food order slip, right? You, as the payer, you're going to write down your order and hand it to the cashier, which is the bank, right? So you're going to write down your order as the payer, and the cashier is the bank. So the cashier checks that you have enough money and then hands the food. But before they hand you the food, they have to check if there's money, right? In this case, they have to take it to the treasury and what? And execute it. They have to properly execute it, right? They got to take it to the treasury and properly turn it in to redeem it. They got to redeem it, right? And if they don't redeem it, they're not going to get it. They're not going to get the money to pay off the balances on the securities and the bonds. So the cashier checks to see if you have money before they hand you over the food, right? So just like an order slip tells a restaurant what to do, right? A check instructs the bank to move money from one account to another, right? And that's just put into simpler terms for you guys, right? Now we'll dive into a presentment. Now, presentment is a demand for payment of a promissory note. So when it is due. So the Uniform Commercial Code defines presentment as a demand by or on behalf of a person entitled to enforce an instrument to pay an instrument made to the drawer or party obligated to pay an instrument, or in case of a note or accepted draft payable to a bank, to the bank, or to accept a draft made to the drawee. A formal notice, a formal written accusation by a court, by a jury made by its own initiative without a request or presentation of evidence by a local prosecutor. So this is a little bit of a different definition, right? There's two definitions, but in this case, we're dealing with the first one, our presentment, a demand for payment of a promissory note when it is due, right? So now what does this mean? Now imagine you win the game at an arcade, right, to get prize ticket. So now you're holding this ticket that you received from the machine that you won tickets from, right? And you're to take it to the counter to redeem it. And once you redeem it, they're gonna give you the prize that you are exchanging the tickets for. And that's what the presentment is, right? It's a presentment. So when they mean by the date of presentment, you're basically you're bringing your ticket to the counter to hand it in, right? The same way, I make a deal with you, right? And say, hey, I'm gonna make a deal with you for $10, for you to give me a ride to the supermarket, right? So I give you the $10 so that you can give me a ride to the supermarket. But if I give you the $10 and you don't give me a ride to the supermarket, that's dishonor, right? Because in the end, you were supposed to get a ride to the supermarket. And in this case, the presentment is your prize ticket, you're redeeming it to get a reward at the end of the exchange. And then timely, again, we talked about this a little bit earlier, right? So in law, it means, right? Timely means completing an action or fulfilling an obligation within a deadline specified in the law, a contract, or otherwise. For example, if a lease stipulates that the leasee must pay within, 5 business days of each calendar month, a payment within such time frame would be considered timely, right? So when we include a specific time frame in the notice, right? So when we say, we would like for you to respond within 15 business days, right? That's timely. You're telling them how long you want them to respond in. So from the date they receive the document, they now from that day on, it's not from the date it was sent, guys. I want you to also remember that because sometimes it takes, depending on how you send it. I know registered mail it took about, I'd say 4 days. It took about 4 days to mail. So let's say, not including the weekend, you let the 4 days go by, and then from there it's 15 business days. And 15 business days, guys, is 3 weeks. So they have 3 weeks, which is technically 15 business days to handle the to handle the instrument, right? They have 15 days to get back to you to process it, and if not, they need to get back with you with some sort of response, whether they accepted it or they didn't, right? But you have to hear from them. That's what the notice is for. So the key why we are doing this, right? And the reason we have to get into this next step is if you don't hold these companies accountable, then they will continue to get away with securities fraud. And it's our responsibility to put them on notice. And, you know, as I've been, sharing some of the info on YouTube, you get a lot of people who are just like, oh, you're gonna get people in trouble with securities fraud. I'm like, man, like if you knew the half of it, it's like the companies are the ones committing the securities fraud. You just don't really know what you're talking about yet. Like you have to read the information, and I will always tell people to read it. I didn't write any of this, right? All of these laws I'm simply sharing as, right, the middleman. I'm here sending the message as a messenger, and I'm reading it from my perspective. But the securities fraud is never committed by us. Because how can you create securities fraud when the amount was issued to you in the first place? And we're just following the instructions that they gave us. I mean, it doesn't get any more simpler than that. When you sit in there and you're reading all the instructions and you're reading all the information, They're telling you what to do, and then they're explaining what to do. Of course, it doesn't make sense at first when you read it. That's the problem with this, right? You're breaking down legalese. And I had to read this stuff like five, six times just to get it, right? I'm not the one time I'm gonna read this one time and understand it, guys. I'm not that smart. I'm just doing the due diligence of taking five, six times to do it, right? I have the persistence to do it. So I can understand it a little bit. But going through and reading this stuff like is important. That's why I'm always going to tell you guys go back and read it because you can come back and then ask questions and then we'll continue to elaborate and dive deeper into the material. But the general understanding of this is super important. Same thing with credit repair, and I give this example all the time. Some people have tried the remittance process and it didn't work for them. So they think it doesn't work. But you have to understand, like, you're the one who has to enforce it. You don't enforce it, of course it's not going to work. Same thing with credit repair. You have to send the letter out, dispute. If it doesn't work the first time, you got to come back around too. You got to put the pressure on. Because remember, I want you guys to remember this, right? Remember this. And this is something I learned dealing with credit repair and like learning consumer law is the burden of proof is not on you. It's on them. The burden of proof is always on them. It's never on you. So if they were to come and say that this is not acceptable, they have to prove why. Why isn't it acceptable? But how can you defend that if you don't quite understand this process, right? Same thing with credit repair. And why the process I share with you guys works is because I know how to force them to force their hand. I know what to say every round. So rather than disputing three times in a row, you simply dispute round one. Then round two, you're going to verify and request how they did the verification, right? Because if I just kept disputing every single round, you're going to get the same redundant response. That's why you have to understand the process, right? And by knowing the process, you'll be able to handle this a little bit different and you'll have a stronger foundation to go after this, right? And that's the ticket to all of this, guys, because it's not going to work for everyone the first time. Like that, I'd hate to break it to you, right? I've had it work when I wasn't doing it the right way, right? At least following all the instructions. And I still had a remedy. So there's people who can get it even if they do it wrong, and there's people who will do it the right way and may not get it the first time. There is no one way to do this, guys, and you're not dealing with the same companies in the end. So you have to be very mindful, and this is why it's important to understand this whole process, understand how round one is, right? Like you're going to send all the notices in the beginning to inform them, educate them, prepare them. You're going to revoke power of attorney, right? So they're not making any decisions on your behalf, and then you're going to enforce it, right? Same thing with credit repair, right? We went into it, we opted out of all the secondary bureaus, right? You take care of all the information holders. And then you can start disputing because now you make it difficult for the bureaus to verify, right? You're doing it in a very methodical way because if you're not understanding how the process works, right? By simply going in and disputing and then it doesn't work, it's just like people are throwing their hands up and like, oh, man, this is not working. That's not true. You just have to have persistence. You got to go after it, right? And that's what my goal is to show you guys. And my goal is to continue to try different things because I'm telling you, like, there's gonna be better ways to do it, just like the credit situation, right? Like, I found faster ways to dispute items, then they didn't work after a while, and then you have to try a new way. So, for us to be able to have success with this, you have to one go into this with an open mind, and two, you got to be ready for whatever has to come with it, right? Whether that be multiple rounds or whether that be just learning more information. But that's the ticket. It is a ticket. And the ones who have been persistent are the ones who are going to see the results. All right. So again, the secret here, guys, is to put them on notice. The same way we're submitting the disputes, guys, disputes are notices. After so many disputes, guys, You can take him to court after three disputes. After three rounds, you can go right to the court. You can file a court complaint, right? And sue them, literally. But you have to dispute the right way. You have to know how to dispute. That is the ticket. And this is why I'm explaining you have to know this information. I can't emphasize this enough. You have to understand this stuff, or enforcement isn't going to mean anything, right? So that's the key here. That's the key here. I'm just reading through some of the comments here real quick. Yes, sir. Brandon brings up a solid point. He said the people at the banks, the corporations, they don't know anything. They have no idea what's going on. All right. Anyone telling you? Yep. He says anyone that tells you that you are leading people to commit fraud are the same people that don't realize that the fraud is being committed on themselves. 100%. They just they don't have any, I don't know, open mind. Like, you just have to have an open mind. You have to be a student. Like, I say this to a lot of the people in the comments. I'm like, I'm a student at best. I'm like, teach me. I'm like, you're gonna bring up a point, teach me. Show me where I can find the info. I'll read it. Like, I don't mind reading. Like, but don't try to debate me on stuff if you haven't put the time and energy to try to read any of it, right? It's just a waste of breath. Like, I don't need to argue with anyone. It's important to find out who trustee that's, yep. So the more you know, the less you pay. Yeah, the less you know, the more you pay. Yeah. I said this myself. I mean, Brendan, you're bringing up a really good points. Guys, the most expensive thing in life is what you don't know. I'm gonna repeat that again. The most expensive thing in life is what you don't know. Literally, right? So if you are just going through life and you're unaware to what's going on, like you have this tunnel vision and everything that people have told you your entire life, it's going to be a difficult road, right? But in the end, like I said, my goal isn't here to give everyone an answer. It's just to simply guide you, right? Because I'm going through this journey just as much as every single one of you. And I know nothing because all of this is information I just cracked, right? And I'm cracking this information and I'm giving it my all because I know at the end of the tunnel, I'm going to be fine. There's so much information out there, guys. So much. But with the community, with people who are here learning the same stuff at the same time, it's gonna go a lot faster because you get the problem solved with people who are going after it at the same time. Everybody here deals with different companies. Somebody's gonna get remedy with a company that another is not dealing with. And now you have someone who you can connect with. And that's the ticket because, you can go look for information everywhere else and it's all skewed, right? And in my opinion, the reason I share all these links is because I don't want you guys to take my word. I want you to go and do the reading yourself. I'm just, like I said, doing the due diligence of trying to make it simple, organizing it, making it structured, because the way you guys are learning from me is how I had to structure it and how to organize it for me to learn. So that's just how I work, right? But the letter that we're gonna continue to talk about, guys, this is built to formally challenge the creditors, right? Their refusal to accept the tender, security, or debt instrument, and it serves as a presentment and notice that the creditor is acting in dishonor by rejecting a valid offer of payment. So there's three things we're invoking, right? The UCC laws here, UCC 3-503 and 603, right? Notice of dishonor and tender of payment. Then there is also this chapter that focuses on the Hobbs Act, right? 18 USC 1951, which prohibits the actual or attempted robbery or extortion affecting interstate or foreign commerce, right? So this section 1951 also proscribes conspiracy to commit robbery or extortion without reference to the conspiracy statute at 18 USC 371. So basically, when these companies are taking our instruments after we've endorsed them and presented it to them, then they're also on the back end demanding that we pay the monthly payment that is due, right? Then they turn around and claim that we haven't made payment. It's extortion. Not only are they not taking the payment that legally is payment, right? I've shown you guys how it's all payment, right? The CFRs, UCC codes lay it out for you. They say it's payment. It's a legal payment. It's called lawful money because the money we think is money today is not real money. The only money that exists is gold and silver, but we don't actually exchange gold and silver. We're exchanging debt, right? So they're simply refusing to take your lawful money, and then they're on the back end demanding that you give them more debt to cover what's owed or allegedly owed, right? So who's supposed to get this letter? You're going to send this to the creditors, right? Again, if you guys are um, endorsing your mortgage bills or your credit cards, debt collectors, you can also endorse, guys, or simply your utility bills. Student loans, you can endorse them as well. But it's going to their indenture trustee. It's going to their indenture trustee. Right. And what it means by if the debt has been securitized, right? So that's literally the bond that you receive. It's a security. Right. That's the bond that you receive. Right. And most of these companies send you those. They send you them, right? They send you a bill or the instrument is going to come securitized and you're going to endorse it. And you're going to restrictively endorse it and you're going to special endorse it and sign it. And then you're going to mail it off this letter, right? So, just to give a general basis of what this letter says, right, is the letter serves as a formal notice of dishonor regarding the refusal to accept my lawful tender payment. So, some of you may be wondering, like, when do I send this? Well, you just wait your business days, guys, right? 15 business days or 30 business days, however many days you gave them, has passed and they haven't actually responded, that's when you would follow through with this, right? You would follow through with a specific letter, right? So this letter serves as a formal notice of dishonor regarding the refusal to accept a lawful money tender of payment. Ignorance of this law does not exempt, and then you put the company from the obligation of this of my payment. Pursuant to UCC 3-311, accord and satisfaction by use of instrument, a lawful offer of performance was tendered in good faith as full satisfaction of the claim, with express intent of extinguishing any alleged debt, duty, obligation, or liability. This instrument was accepted for set off, discharge, and settlement of this account. So we're reminding them, like, based off of these laws, right? We accepted this instrument so that we can settle the payment. Okay. I must remind you guys what a payment actually means, right? Payment means to fulfill a promise. Okay. It means to fulfill a promise. Where is it? Gonna find the definition I had. It was defined, a lot definition. So I want to cite this for you guys because you're technically making a payment. All right, here, contract formation. So, guys, remember, this is all contract law. A payment fulfill promise, right, is a core element of contract law, which is a promise to pay in exchange for a promise to perform or for an actual performance. It's that simple. So, when you look at it, and this is all based in contract law because we're dealing with a contract. And when you're dealing with a contract, the contract basically we're dealing with is the securities agreement, right? The security agreement is the contract we have with the indenture trustee stating that we will make X amount of payments every month on a specific date, correct? So when you fulfill a promise, so based on contract law, you fulfill a promise by making the payment because you had originally promised to pay, and now that you're promising to pay, right, in exchange to perform, right, or for an actual performance, they're not accepting your performance to pay. You basically already paid. All you need to do is promise and fulfill, all you need to do is fulfill your promise on your end in order for the payment to be completed. It's no different, guys, than giving someone a verbal contract, right? If I tell you, yeah, I'll help you out tomorrow, and then you go help them out, that you fulfill the promise, right? You've made a payment to them, right? That's a verbal contract. On paper contract, right? We're dealing with contract law where a payment fulfill promise is a core element of contract law, right? Where a promise to pay is exchanged for a promise to perform, and you're performing by simply endorsing the instrument and sending it to the proper party, right? For them to set off the payment and set off and discharge the debt, right? It is a settlement. And we also provided instructions to them to do so, right? Now, continuing on with the letters. Furthermore, it is evident that the company is utilizing my exemption as such. Equality under the law is both paramount and mandatory in accordance with established legal principles. Now, should the company continue to act in dishonor, this letter serves as further presentment. So we're further present it's a further presentment in this case in a formal notice of dishonor. So we're attempting to give him another opportunity to handle this. That's the point of the notice. And we're going to give him another opportunity to handle this, right? And we're citing all of the laws here that they are supposed to be following. All right, so if the tender of the payment of an obligation to pay an instrument is made to a person entitled to enforce the instrument and the tender is refused, there is discharge. to the extent of the amount of the tender. So if the obligation of the endorser or accommodation party have a right of recourse with respect to the obligation to which the tender relates, right? And what it means with the right of recourse, right? And you've seen it on a lot of these letters without recourse, that basically means, guys, you can't be held liable, right? Without recourse means that the endorser disclaims liability to subsequent holders of negotiable instrument, meaning that they're not responsible if the instrument is dishonored. You understand that? What without recourse means? So you can't be held liable for the payment if you've already endorsed it, guys. That's why we place the without recourse on the instrument. When we also signed the endorsement, when we signed the security document, we put without recourse on it because you can't be held liable for it if it's not honored. That's what it says. That's not me saying it, guys, right? That's what it says. That's what the law says. So that's why we use without recourse at the end of the document is because that's what it means. Now, furthermore, UCC 3-604, discharge by cancellation or renunciation, subsection A, affirms that a person entitled to enforce an instrument with or without consideration may discharge the obligation of a party to pay the instrument by an addition by an intentional involuntary act, such as surrender the instrument to the party, destruction, mutilation, or cancellation of the instrument, cancellation or striking out of the party's signature, or an addition of words to the instrument indicating discharge, or by agreeing not to sue or otherwise renouncing the rights to the party. By refusing to accept my good faith tender, the company is in breach of fiduciary obligations and has agreed to discharge the debt. Now, do you see what I mean, guys? We're still dealing with the trustee. The trustee has a fiduciary duty to act on your behalf. Now, are they acting on your behalf or in your best interest, right? Because that's what fiduciary means, right? To act in your best interest in this particular case. It's their responsibility, and this is where they're breaching it if they don't accept it. You're giving them an opportunity with this letter to accept it, right? Right? You're giving them an opportunity with this letter to accept it because of the simple fact that if they don't, then you will then pursue the next round, right? And then we'll talk about round three on the next call, right? I'm going to drop that as one of the options for our weekly call. Although some of you will still be working through round one and two, it'll still be up for grabs. Round three is a letter for intent to sue. We're going to basically be walking through like the final notice because you want to go through three notices, just like credit repair, guys. You can give them three notices, and the third and final round is a notice before you take them to court, right? And that's how that pretty much works. But I've pretty much gone over that letter, right? You guys have full access to it right here. Right, I break this all down. Like I said, I encourage you guys to go through and read all of this material. It's available right on Cornell. I just simply, put the links here for you for convenience so you guys don't have to, search it up on your own. You can basically check it all out for yourself. And then the letter is available down here for you guys to, simply copy and paste and just fill in the blanks. And then you're going to take it to a notary before you mail it out. All right. You're going to take it to the notary before you mail it out. Now, before we end the call, did anyone have any questions? Let me go through the chat to make sure I covered everything. It says, so Manuel asked, can I send a coupon to them along with a 1099C? Directing them to wire my treasury direct, ensure they properly process my 1099C, including sending a copy of because all debt cancellations should be reported. Well, You see, it depends. You're asking a very broad question, Emmanuel. 1099-Cs for debt cancellation. Um, 1099, like I said, I'm gonna be going over this tomorrow. So I think this is a good question for tomorrow. I'm gonna I'm gonna screenshot this picture. I mean this question and we'll go over that tomorrow. So there 1099A and the C serve completely different processes, right? And I don't want to dive deep into this right now, but your question is very broad, Emmanuel. It's like hard for me to answer because it could mean one of two things, right? Because you're asking about using the 1099-C in this letter, right, and sending it to Treasury Direct. Like, I'm not understanding like what for, right? Because a 1099-C is to cancel debt, right? And for my understanding, you could use a 1099-C for things that have been charged off, right? But in this particular case, you got to be a little bit specific about what it is. But I think this is a great question to bring to tomorrow's call because I'm going to be going into 1099A and B instructions. I'm going to be covering those instructions, what they mean, what you should use it for, when you should use it, so that you guys can have a general understanding of that. And I'll just be revising all of the instructions so you guys have a more simplified understanding of how that stuff works, right? Because at the end, I'm always going to tell you it comes back down to the instructions. It 100% comes back down to the instructions. I don't have the answers. The instructions have the answers, right? The instructions are always going to have the answers. Even dealing with places like the IRS. If you call the IRS today, they're always going to tell you, we always go back to the instructions because the IRS has specific instructions in all their documents, right? Let me TDA. He means send security to TDA account. Oh, yeah. So if you're trying to process this through the TDA account, that's completely different. Like you're looking to do the medallion process. Like you go to the bank and you set up your TDA account, Treasury Direct account. You got to go and set that up with the bank. You got to go through a very specific process. I haven't done that process yet. I'm familiar with it, but I haven't done it. Um, so to answer your question, if this has to do with processing like the medallion stamp, because that's what you're doing at that point, right? You're processing it through the bank through a medallion because it's gonna go straight through your TDA account. I haven't done that process yet. So 1099-C helps direct the securities back to your Treasury Direct account along with the total amount you have paid towards the security since opening the account. Yeah, that makes sense. I think that's a back end though. If I'm not mistaken, I think that's the back end. I think you go through and endorse everything, process it through the bank, and then you fill that document in after. That's my understanding of it. Because when it comes to cancellation of debt, the companies that cancel the debt have to fill out a 1099-C in order for you to redeem those credits, or you have to fill out the 1099-C to redeem the credits. But like I said, it's very like important to understand the differences between those and how that works. But I don't want to quote anything and I'm not 100% on the TDA process. Like I'm not gonna, cover details on, anything I really am not 100% on, right? I'm familiar with it, but I'm not having like dove deep and read it multiple times to feel confident in giving you the correct answer. But really good questions though, man. I appreciate you asking. And anyone else have any questions? Let me open it up for you guys. Give me a sec. Yeah. Anyone else have any questions? I've opened up for you guys to chat. You can ask me any questions before we end the call. That way, we can touch base on things. Maurice, you're asking, should we call them? Call who? Like the bank? Like for the TDA accounts? Should you call them? You can, right? Just like you can call the credit bureaus. You can call the credit bureaus just to confirm they received and accepted tender. Remember who you're dealing with, though, guys. You're dealing with the public, so you're going to be calling people who may not even know what you're talking about, right? Like you're going to be calling them, and you're just not going to know what you're talking about. Like I'll give you an example. I was on the phone today with Equifax, no, Experian. And of course, I'm dealing with, one of the subordinates, like the initial team members, and I'm trying to get a supervisor on the phone. And he's like, "Well, I can answer pretty much anything, supervisor can." I'm like, "I don't think so." And he was adamant. So I was like, "All right, can you help me with this?" And surely but not, he was just so convinced that, you know, the dispute that we were trying to process wasn't disputed that way. And I just like, you know what? Like, I'm not even gonna waste my time. So I just got on the phone with a supervisor and we handled it. So calling them, it's not always the answer. Who to call is the good question. Is who should we call? That's a real good question. And in this particular case, the most effective thing to do is to just simply follow up via letter. Like just follow up via letter because that's what the notices are for. And I have run into situations where they do call, like the companies will call you and they will ask you questions about the payment. And what I did personally, right? Personally, I just said, I don't feel comfortable discussing this over the phone. Can you email me at this or send it to my email or send it via mail? Of course, they don't want to. They don't want to respond like that. Um, and nine times out of 10, the people who are calling you, they don't understand what's going on. So to answer your question, Maurice, it's a good question. It's 50-50, man. Like it's all going to come down to who you call, based off, like I said, what I've experienced. Talk to these people on the phone on both sides, credit and in this endorsement side. Like some people just don't know what we're talking about. They just don't. I actually got an example. I sent I got an email for a new account I set up with AT&T, and T, and I sent a question out, just like messing around. I was like, "Hey, do you guys deal with endorsements and bill remittance?" Because in the email it stated that we help with bill payments, etc. And then I shot the message out, and she was like, "Oh, can you elaborate a little bit more?" So I did, and she still didn't understand what I was talking about. So I'm like, in the end, it all is gonna come down to who you're dealing with. It's all gonna come down to who you're dealing with, and that's why I say the more foundation you have, the more you can enforce it over the phone, the more you can know who understands what you're talking about. And but in my opinion, the ticket is letters. A ticket is letters. Unless you find a reliable source to connect with, um, you know, I wouldn't be opposed to calling like the indenture trustee numbers. I wouldn't be opposed to that. I'll give it a try myself. I'll let you guys know how it goes. Like I said, I do it all. Like I'm just gonna be doing it. So I'll give an indenture trustee a call. I've been doing everything by letter to see who knows what and who I can talk to. And I'll let you know where I find. But that's just gonna be like one company out of many, guys. There's so many out there and they all do things differently. Um, and that's why we gotta get the reps in. We gotta get the reps in, get the letters in, get everything sent, follow up, enforce. No, I've been working on round three. I'm there now. So I built the letter for round three. I learned it from I got a bunch of letters from script. I looked at the laws, like I studied like what to use because the letter is an intent to sue. So we're basically giving them a third and final notice, similar to a notice of action when I send a letter for credit repair, right? I usually send them like a notice of action. And usually when I did that, I got remedy in the credit space. But in this particular case, I'm not there yet, but I'm almost there with the round three. I'm waiting on response. Have I gotten anything endorsed before round three? Yeah, I've gotten remedy, guys. I've gotten remedy on my AT&T bill. But there's other accounts I'm working on right now. Like I'm helping my mom with all her stuff, and we're on our way to round two, right? For hers specifically, because she's got like the light bill and the solar and gas and water, like because she's got the house. So we're doing all of that. We're on our way to round two. We're just waiting to hear back. I'll keep you guys posted on where we go with that. That answer your question, Maurice? Perfect. Yeah. So all of it is just the process. What I'm trying to figure out is I've seen people, yeah, some people like I don't know if you guys saw. I mean, I shared with you guys earlier. I'll share it and pin it in the wins, but one of our students got remedy. He posted it here. We're supposed to get it posted. Here it is. So uh Jared got his best friend bill spent because he sent off his bill. Said I watched videos closely, took action. We have success story, right? It's my friend, business partner, sent off his bills properly endorsed, and I got one of them paid 5,600 worth. We celebrated together by jumping up and down. It didn't pay. I didn't pay the entire balance. That way it remains open. I only left 484 as a balance. Now I'm sending the bills again and with all the necessary documents. All right, we're sending this POA or his POA affidavit and letter notarized tomorrow. 90K worth of credit card debt. Fingers crossed. I'll keep you updated. Right. So, and I believe he sent an example of it right here. So you see that it was a conditional credit for payment right here for 5608, and that was March 2nd, guys. That was just the beginning of this month. And keep in mind, guys, like I released these videos in the last month and a half. It hasn't been that long. Like these videos have been on YouTube for a very short period of time. Because again, I'm sharing in the videos like my journey as much as it is yours, and where I've gotten to this, right? Because I had started this way back in October, um, and I had received remedy, and then since then I hadn't because I was trying different things and I was learning and I was trying to figure out why it wasn't working the second time around, and that's how I stumbled upon all these other different ways. But yeah, that's a big win. That's a big win. So yeah, it's like I said, it's possible, man. Like anyone can get it in the first round. And if you don't get it in the first round, just keep in mind you got to do it again. Like you got to keep getting after it. And different companies are different, but the key is in the reps. Any other questions, guys? These are all good questions. Good to go. Awesome, man. Well, tomorrow, guys, we're gonna dive into the instructions for the 1099 A and C, just so I can read over how I understand what those documents are, how they work, and we'll go from there, man. In the meantime, drop any other questions in the Q&A, and I'll get back to you guys as soon as possible. Other than that, you guys have a great night, and we'll see you guys tomorrow. Sound cool? Awesome. Take care, everyone.